I want to start today by putting you in a very specific, uh, very uncomfortable headspace.
Okay.
Imagine you're in trouble. And I don't mean I lost my wallet trouble. I mean the kind of trouble where you genuinely fear for your safety.
The kind of situation where the average person just feels completely out of their depth.
Right. So you do the one thing we're all taught to do,
Yeah.
since kindergarten. You go to the authorities.
Mm-hmm.
You walk into a police station. You write down your grievance, hand it over. They stamp it. And you walk out thinking, okay, the system knows I've done my part. The safety net is there.
That's the social contract, right? You trade your tax dollars and your obedience to the law for the expectation of protection.
But then nothing happens. Just silence. It stretches out.
Yeah.
And you're still in danger. So you escalate.
You go to court.
You go to the high court, which is a terrifying place for a normal person.
Right.
And you tell the judge, I asked for help and they ignored me.
Yeah.
And then the government lawyer, the police, all of them stands up and says, Your Honor, this person is hallucinating. They never came to us.
We have zero record.
We have zero record of them ever asking for help.
That is the ultimate gaslight. I mean, it's one thing to be ignored because of incompetence. It's something else entirely to be erased from the record.
And because the state is the state, the judge believes them. He looks at you, this lone citizen, and essentially says, stop wasting my time. Case dismissed. You walk out with a court order that basically brands you a liar.
It sounds like a dystopian thriller, doesn't it? But what we're diving into today is a legal transcript where this isn't a hypothetical. This is the exact nightmare scenario a citizen faced.
We're looking at a document titled The Constitutional Duty of Fact in State Protection Trials.
Right.
And honestly, when I first saw that title, I thought it was going to be, incredibly dry.
Legal jargon.
Yeah, procedural stuff. But it's actually a transcript of an oral argument. And it's presented by a petitioner in person.
And that detail, petitioner in person, that's where you have to start. It changes the entire texture of the story.
Okay, yeah, let's clarify that for everyone. This isn't some high-powered lawyer in a silk robe, right?
No, not at all. This is the individual themselves, standing alone before your lordships, the high court bench, arguing their own case against the entire machinery of the state.
Sure, imagine the intimidation factor there.
Oh, it's immense. You've got the state prosecutor, police officials, their legal teams, and then just you.
And usually, that's a recipe for getting completely crushed. But this petitioner didn't get crushed. They came back fighting.
They did. And the mission of this deep dive is to unpack exactly how they did it. We're looking at a legal battle that really hinges on this single, massive, glaring divergence.
The petitioner calls it the tale of two pictures. I love that framing. It's so cinematic.
It is. On one side, you have the official record. On the other, you have the story the state told the court. And we are going to see how a few sheets of paper, something called Annexure P6, might just prove that the state's entire defense was, well, built on a lie.
And not just a little white lie, either. We're talking about what the petitioner calls a constitutional crisis.
Exactly. This isn't just about a clerk losing a file. It's about whether the government has a fundamental duty to tell the truth in court. Because if it doesn't, the whole system of justice just falls apart.
So let's get into this tale of two pictures, because the transcript sets this up as the core conflict. The petitioner literally frames it as picture A versus picture B. Break that down for us.
Okay, so picture A is the reality the petitioner lived. In this version, they went to the senior superintendent of police, the SSP. They submitted a representation. They explicitly said, I am under threat. They followed, every rule in the book.
Okay, so that's the physical reality on the ground.
Right.
Then we have picture B.
Picture B is the narrative the state presented to the Punjab and Haryana High Court. In this version, the petitioner never approached the authorities. The state stood up in court and said, effectively, we don't know what this person is talking about. They never came to us.
Here is what I struggle with. In a he said, she said between a random citizen and the state, why does the court almost automatically believe the state? Is it just bias?
It's not necessarily malice on the judge's part, but it is a systemic bias. There's a legal concept called the presumption of regularity.
Presumption of regularity.
Yeah. Courts generally assume that public officials are doing their jobs honestly and that official records are accurate.
So if the prosecutor says, we checked the database and he's not there, the judge just assumes the prosecutor actually checked the database.
Correct. The judge assumes the state is a neutral keeper of the record. So when the state said, he didn't come to us, the High Court dismissed the petitions based on that fact.
The judge thought, well, you have to exhaust your remedies with the police first. Since you didn't, get out of my court.
Precisely. So the dismissal wasn't because the petitioner wasn't in danger. It was on a technicality that it seems the state completely fabricated.
That brings us to the core legal argument.
Mm.
The petitioner claims this is a continuing Article 21 violation. We hear Article 21 thrown around a lot.
Yeah.
It's life and liberty, right?
Yeah.
But why is this an Article 21 issue? It feels like a paperwork issue.
And that's the brilliance of the argument. Article 21 guarantees protection of life and liberty, but it also says the state can only interfere with that liberty according to procedure established by law.
Okay.
Well, think about it. If the state lies to the court to avoid providing security, they aren't following the procedure established by law.
They're subverting it.
They're subverting the procedure. The petitioner is arguing. By lying about the facts to deny me protection, the state is actively endangering my life. They are stripping me of my constitutional shield.
I see. It shifts the blame. It's not just the police are lazy. It's the state is actively defrauding the judicial system to avoid doing its job.
Exactly. It raises the stakes from a simple grievance to a full-blown constitutional breach. But, making that accusation is one thing. Proving it against the government, that's usually impossible.
Usually. Unless you're the type of person who keeps their receipts.
And this petitioner, they kept the receipts.
So let's talk about Annexure P6. It sounds like a secret weapon. And in this context, it kind of is. The source text describes this document with such specific detail.
This is where being a petitioner in person might actually have been an advantage. A lawyer might have argued legal precedent. This petitioner argued the logbook. They present a document. Diary entry num 4045 SSP.
I want to pause on diary entry.
Yeah.
To a layperson, that sounds like a personal journal. Dear diary, today I went to the cops. But that's not what this is at all, is it?
No, absolutely not. In police administration, the diary is the nervous system of the station. It's the chronological, immutable log of everything that comes in and goes out. It has a serial number. It has a date. Once something is entered in the diary, it legally exists in the universe of the state.
It can't be deleted. Or shouldn't be.
It shouldn't be. And we have a specific date here, too, right?
Yes, June 18th, 2025.
Yeah.
So June 18th, 2025, Office of the Senior Superintendent Police, SS Nagar. A specific number, 4045. The petitioner then walks the judges through this document page by page.
And this is the smoking gun moment. Let's look at page 30 of the annexure.
What's on page 30?
Page 30 is the receipt. It shows the threat representation was physically received. It is stamped. It is signed. Right there, the state's claim that he never came to us is objectively, factually false.
But I can hear the state lawyers now. Oh, maybe it got lost on a desk. Maybe it fell behind a filing cabinet. Some excuse.
That's why page 31 is devastating for them. Page 31 shows the movement of the file. It documents that the representation was forwarded to the DSP, the Deputy Superintendent of Police of Zirakpur.
So it wasn't just received. A superior officer looked at it, processed it, and sent it down the chain of command for action.
Exactly. The bureaucracy was working, the gears were turning, and then page 32 shows it was taken up for examination as per police rules.
This is what the petitioner calls the official police trail.
Yes, and note the confidence in that phrasing. This is not an inference. This is the official police trail. This isn't the petitioner saying, I swear I went there. This is the state's own handwriting saying, we have this file and we are processing it.
It's just incredible. You have receipt, forwarding, and examination. You have a diary entry number. You have signatures. And yet, despite all of this, the state stood in the high court and said, nope, never saw it. How do they get away with that?
It speaks to a staggering level of disconnection or maybe arrogance within the state machinery.
Right.
Either the right hand doesn't know what the left hand is doing, or worse, the right hand knows the left hand is holding the evidence and just decides to lie about it anyway.
Because they assume no one will ever check.
They assume the petitioner in person won't know how to navigate the system to get that copy. They banked on the citizen being overwhelmed. But this citizen dug up Annexure P6.
I can just picture the scene. The petitioner holding this document up in court. Here is the number. Here's the stamp. Now tell me again that I don't exist.
It completely changes the nature of the case. It stops being about, do I deserve protection? And starts being about, can the court trust a single word the state says?
Which leads us to the legal strategy. And this is a part that really surprised me. And I need you to walk me through it. Because, naturally, if a court makes a decision based on a lie, your next step is to file an appeal.
That's a standard playbook.
You go to a higher court and say, hey, the first judge got it wrong.
Yes, 99% of lawyers would file an appeal. But this petitioner is doing something much more subtle and, I think, legally much more dangerous for the state.
The source explicitly says this petition is not an appeal. Why? If the previous order was bad, why not appeal it?
Because think about what an appeal implies. An appeal suggests that the judge made a mistake in judgment based on the evidence they had. You're asking a higher court to reweigh the pros and cons.
Okay, so you're saying Judge A interpreted the law wrong.
Right. But the petitioner here is arguing that the judge didn't make a mistake in interpretation. The judge was tricked. The judge was fed false data.
Ah, I see the distinction.
Yeah.
It's not the judgment was poor, it's the judgment was rigged.
Correct. The petitioner is relying on a very, very heavy legal principle. Fraud or material misrepresentation vitiates judicial proceedings.
Vitiates. That is a serious word. It sounds like something that rots from the inside out.
That's actually a great analogy. Think of it like a poisoned well. If you drop poison into the source of a river, everything downstream is contaminated. Vitiates means it invalidates it entirely. It renders it void from the very beginning.
So the argument is, if a court order was obtained by lying to the judge about the facts, that order isn't just wrong, it's a nullity. It shouldn't even exist.
Exactly. If the foundation is a lie, the house cannot stand. The petitioner frames the narrow constitutional issue like this. Did I approach the police or did I not?
It's a binary question, yes or no.
It is. And if Annexure P6 proves the answer is yes, then every single court order that assumed the answer was no is, fruit of the poisonous tree. It lets the petitioner bypass all the messy arguments about threat perception and focus entirely on the state's conduct.
That is such a smart pivot. It just cuts through all the subjective noise. It forces the state to answer for that diary entry.
And it puts the court in a bind. Because if the court ignores Annexure P6, they are essentially saying it's okay for the state to lie to them, and no judge wants to set that precedent.
So, practically speaking, what is the petitioner dealing with right now? The source mentions a continuing injury. What does that mean?
This is the practical side of the legal theory. The injury isn't just that they were denied help last year. It's the fact that even today, right now, when the petitioner asks for help, the state points to those old, tainted high court orders.
It's like a zombie order. It keeps coming back from the dead to hurt them.
Exactly. The executive branch, the police, is using a judicial order that was based on their own lie to justify doing nothing in the present. They say, look, the high court already dismissed you. We don't have to listen to you.
It's a circular trap. The police lie to get the dismissal, and then they use the dismissal to justify the lie.
Which brings us to the relief the petitioner is seeking. They aren't asking for millions in damages. They're just asking for interim relief.
Just a pause button.
Basically, two specific things. First, they want the court to order the state to stop relying on the impugned orders, the flawed ones, to deny protection. Essentially, you cannot use your own lie as a shield anymore.
And the second thing?
Second, grant interim protection while this whole mess is sorted out. Pending final adjudication, just keep me safe.
It seems so incredibly reasonable. Please don't let me get hurt while we figure out why you lied about my paperwork.
It is reasonable, but I want to circle back to the petitioner in person aspect for a second. To get to this point, to find the document, to understand the legal theory of vitiation, to stand up in court and articulate this constitutional duty of fact, that takes an immense amount of persistence.
It really does. I think most people, myself included, probably would have given up after that first dismissal. We would have doubted ourselves.
Of course.
We would have thought, maybe I didn't file it right. Maybe I went to the wrong office. Maybe I am crazy.
That's the psychological power of the state. When the authorities tell you this didn't happen, your first instinct is to doubt your own reality. This petitioner refused to do that. They held on to diary entry in 4045 like a lifeline.
It's such a powerful reminder of the importance of documentation. We live in this world where we think digital records are everything, but sometimes you need that physical stamp. You need that paper trail.
Absolutely. In a battle against a massive faceless system, sometimes the only thing that saves you is the ability to point to page 30 and say, no, look, here is the stamp.
So zooming out, what's the bigger takeaway here? Beyond just this one person and their safety, why should we, the listeners, care about the constitutional duty of fact?
Well, we often talk about the duty of courts, to be fair, or the duty of police to prevent crime. But this case highlights something even more fundamental. The government has a duty to be truthful when it speaks to the judiciary.
Because if they aren't, the whole system of checks and balances just doesn't work.
Completely. The justice system relies on the assumption that the state might argue about how to interpret the law, but they won't just invent facts. When the state says there is no record, the court has to be able to believe that.
If that trust is broken.
If that trust is broken, if the keeper of the record is lying about the record, then the citizen has no recourse.
It turns the court into just a theater, where the outcome is predetermined by whoever hides the evidence best.
That is why the petitioner calls it an Article 21 violation. By falsifying the narrative, the state didn't just win a case, they stripped the petitioner of their constitutional right to even access the justice system at all.
It's a wild realization that a clerical error or a clerical lie can effectively suspend the Constitution for one person.
And that's why this argument of fraud vitiating proceedings is so critical. If the petitioner wins this point, it sets a precedent. It tells the executive branch, if you lie to get a dismissal, that dismissal is worthless. You cannot build a victory on a foundation of fraud.
It's a comforting thought, in a way, that the truth, if you can prove it, still has power over the system.
If you can prove it, being the key phrase there.
Right. If they hadn't found Annexure P6, we wouldn't be having this conversation. Picture B would be the only picture, and the petitioner would just be another dismissed case in the archives.
And that's a lingering horror of this story. How many other Picture B cases are out there? How many people went to court, were told, you never asked for help, and didn't have the diary number to prove otherwise?
Where the file just accidentally vanished before it got to page 31.
Exactly.
That is a chilling thought to leave on. We rely so much on the official narrative. We assume that if it's in a court order, it must be the truth.
But here we have proof that the official record and the actual facts can be total opposites.
So here's a question for you to chew on as you go about your day. In the eyes of the law, what is the truth? Is it what actually happened to you? Or is it what is written down in the court order?
And if those two things contradict each other, which one wins?
And more importantly, do you have your own Annexure P6 ready in your back pocket, just in case you need to prove you exist?
A very disturbing but very necessary question.
Thanks for diving in with us. Check your receipts, everyone.
Indeed. Stay safe.